Everybody's pretty much ready. Our next case is University of Iowa Board of Regents and State of Iowa versus Modern Piping, Inc., and we will begin with Ms. Register.
I was about to explain a lot to those kids. Glad they left.
Did you go to high school?
Yep. I'm from Los Angeles. I went to Burbank High. Go Bulldogs. May it please the court, counsel. This case is about an injunction, what it ordered, and more importantly, what it did not order. An injunction here temporarily enjoined the AAA, an arbitrating entity, from presenting the, not any, the dispute over the Children's Hospital project to arbitration until further order of the court. Modern Piping misreads this injunction and then parlays that misreading into the exceptional remedy of disgorgement. But I think the law is clear that wrongful injunction actions, which function like strict liability, rise and fall on what the injunction actually mandated by the order and not by subjective understandings or subjective misunderstandings of what it ordered. And because of the injunction here, a particular specific arbitration proceeding that could have began in the spring of 2016 began in the spring of 2017. It was delayed. And the university's benefit of that injunction, the benefit from the delay, was it paid an arbitration award later than it otherwise would have. But the university has not retained the benefit of that delay. When the only arbitration proceeding that has ever been enjoined in this case resumed and completed, the university paid nearly $1 million in interest dating back to the date of the initial demand before the injunction. And so the university's injunction here did indeed cause a delay. The university has not been allowed to benefit from the delay, and Modern Piping has received nearly $1 million more than its actual damages as compensation for that delay. Because this case is about unjust enrichment, it's dispositive in my view that the university is still not in possession of any property of Modern Piping's that it received because of the injunction, nor has it retained any benefit it received because of the injunction. So Modern Piping is not entitled to any unjust enrichment in this case. There's a couple background facts that I think are really critical here. The first is how you obtain the right to arbitrate under the contract in the first place, because it doesn't start from the beginning. There's a timeline. So if you're going through the construction and you're having disputes and you think someone's breaching, you don't have an immediate right to arbitrate that. You have to exhaust. There's an exhaustion procedure. And so under 4.4.2, you have no ability and thus no right to arbitrate a dispute until you submit your issue to the design professional, and then you wait 10 days. And the lesser of the date, so if they give you a decision 2 days later, you then have the right to arbitrate. If there's no decision, if they don't do anything with it, if they don't acknowledge it, you wait the whole 10. On day 10, your right to arbitrate vests. And this is really important here because in 2016, a district court held that Modern Piping had complied with that exhaustion mechanism over a Hampshire project and said, yes, they have exhausted, this is subject to arbitration, and it compelled that arbitration. But shortly thereafter, Modern Piping wanted to piggyback a separate $8 million arbitration of exhausted claims over a separate contract, a separate project at Children's Hospital. The University of Iowa disagreed.
Because, I mean, reading the briefs and now listening to the argument, it kind of, it's sort of like a lot of jousting on Game of Thrones, and I have trouble following it. It's happening so fast. But let me try and simplify my understanding and tell me, here's what kind of bothers me about the case as a whole, and I'm going to ask the appellees this as well. But it strikes me that if what the university did is it went ahead and opened and started up this children's hospital while the construction was still going on. And that should, in the ordinary course, would have entitled Modern Piping to another $2.5 million. And so I don't, if there had been no injunction. The injunction didn't enable them. I don't understand how the injunction would have enabled the opening of that hospital that wouldn't have otherwise happened. And so I don't understand why Modern Piping is entitled to something more than $2.5 million, maybe with a bit more interest because some arbitration proceedings got delayed. But that's kind of my simplified look. Is that wrong, or am I misunderstanding the situation?
Equate the breach with the injunction. right? So to get to the 2.5, you have to find that the breach was only made possible and would have been impossible without the injunction. The problem there is that the injunction did not sanction a breach. It did not bless a breach. It says nothing about partial occupancy. And I think had the injunction voided the contract entirely, had it relieved the parties' obligations to perform, I think at least we'd have a conversation about a causal nexus between eliminating a contract obligation and not performing under that contract. But what the injunction did is said, hey, that $8 million thing, that can't go right now. It didn't say anything about future disputes. And so the problem with the 2.5 is that those are breach damages. The University of Iowa never exhausted their remedies, so they've never.
Point factually helped me. I think the other side argues that the design professional was sort of shut down during that period of time. What's the story?
So under the contract, the design professional is a neutral person. And so there's an email that says, we don't want the design professional to look at it. But that's not how you ripen or vest your right to arbitrate. You just have to say, design professional, please see attached and wait 10 days. And so this person is a neutral person and both parties can do it. This wasn't someone under our direct control. And at this point in the contract, it specifically talks about the fact that they're neutral, they're fair to both sides. And so we couldn't factually under the contract do that. And so they did have an obligation to exhaust, and the injunction did not take away their ability to do that.
With the $8 million, and the $8 million had nothing to do with the partial occupancy, right?
Yeah, right. And so they thought we had breached to the tune of $8 million, and they wanted to piggyback that on.
Completely unrelated to what we're talking about today. Okay.
Alleged new breach that they say was impossible but for the injunction hadn't even happened yet. And I just think there's no causal connection there because the injunction did not allow the breach. It did not greenlight the breach. It didn't void the partial occupancy clause. I think there's a lot of ways we could change the facts where it would relieve our obligation to perform, but it didn't. And so there's no expectation, right, that there would be no consequence for the breach. And so I think, if you boil it down, and back to your question of how do we not get to 2.5, if we boil it down, they abandoned their breach of contract claim. 2.5 is their breach of contract damages. They did not exhaust it, and they didn't exhaust it after the injunction was lifted either. Right? And so I think what you hear in their briefs is a correlation argument, right? They got this injunction, and then all of a sudden they move in, right? So how could that not be related? But let's take that correlation principle further, right? As soon as this injunction is lifted, they don't refer to the design professional. They don't exercise their rights. They never sue us for breach of contract. And so if you're reading through the trial testimony of what their claim damages actually are, you hear time and again, I wanted to get paid for this. I never got paid for this. Well, they never sued us for breach. That's why they didn't get paid for it.
A little bit on the legal part. It seems to me, even if we go in and kind of dive into the weeds on the law, I still have trouble getting beyond 2.5 million because what my understanding is for wrongful injunction, the standard remedy is the amount that you've been harmed by the issuance of the injunction.
Yeah.
The best scenario, it seems to me, they've been harmed by 2.5 million. Now, if you've gained by some different amount than 2.5 million, then that's the sort of the disgorgement. Then that strikes me as that sort of an unusual principle that you have to resort to, and that would be limited to a situation where you had the benefit of their property, like a patent or physical property or something like that. Whereas we're still always talking about money. You didn't have their property, and that's so even okay. Thanks.
Cannot agree that the breach has any causal connection to the injunction, right? They're saying to the extent you phrase it as the injunction harmed them by 2.5, the breach harmed them by 2.5. The injunction did not do that. The injunction did not make them abandon their breach of process claim, or abandon, their breach of contract claim. And so there's just no causal connection there. Sure.
It's the university's property. It's the university's hospital. They could start using it whenever they wanted to.
Yeah.
Subject to consequences, whatever. But under no circumstance was Modern Piping kind of the owner or possessor of this hospital and had some right to use it for a profitable purpose other than what the university was going to do, right? Okay.
Profitable purpose, no. But you've hit on a good point, what I wanted to clarify, which is that, they mentioned in their brief that they had this right to exclude, and that was one of the property interests that they say was taken from them. The problem there is an evidentiary problem. They did not try to exclude, and we know from the trial that they would not have tried to exclude. All of Shive's testimony was about getting paid, right? If you read through the trial, the only time the right to exclude or I would have gotten an injunction to kick him out, that comes from Modern Piping's counsel talking to the judge or the jury, and that's just not evidence. The only evidence in this case of what they actually would have done that they felt they couldn't do was get paid for the breach, but they abandoned that breach of contract claim.
Expressly allowed the hospital to go in early, but subject to you had to get this a partial occupancy agreement.
Their theory there is that, the injunction, I think, emboldened them to not come to the negotiating table. There's a case I really like for this set of facts, and it's Mattel. The kids would like it. It's about Barbie. But it's Barbie versus Bratz. And Barbie got an injunction for 8 months preventing new Bratz dolls from being manufactured. Not sold, not distributed, manufactured. No Bratz dolls were taken off the shelf. And so for those 8 months, the injunction was wrong, shouldn't have been issued, got a return. Bratz comes back and they want disgorgement. They want their profits. And they said, yes, the injunction technically did not take anything off the shelves, but the specter of the injunction and the purpose of the injunction, what they were trying to do was hurt sales and give themselves an advantage in the market, and we shouldn't sanction that. And the court in Mattel said, no, we look at the four corners of the injunction. Nothing was ordered because of the injunction to be taken off the shelves. And so we're not gonna indulge this kind of specter argument or the fact of the injunction argument. And I read this as really analogous, right? I think they're saying the injunction emboldened the university to breach, or the fact of it emboldened them to breach. But that's not how these claims proceed. And again, I think it's really important that these function as strict liability, right? And I think the fact that they're strict liability imposes a court an obligation to read it strictly, right? We're deprived of defenses of good faith, so we have to be held to the four corners of what the injunction actually did. And this injunction was about the timing of a particular arbitration proceeding. In fact, the only arbitration that was ever vested in this case.
What about the separate award by the jury of the costs and fees for $21,000 and change?
I think under City of Corning, that's squarely available.
Been what they would have been entitled to on their original motion for costs and fees that was filed before the appeal?
Like 30 grand less. I'm not mad at that, so yeah. A couple notes, again, on disgorgement, because it's not just that they're seeking restitution. I think you're going to hear an argument today that this is about restitution, it's about equity. But the particular theory here that they're seeking is disgorgement. And that is a rare and disfavored remedy, right? They point to the restatement, but that restatement has actually not been adopted or followed by very many courts, if any. And there's a really nice discussion in Kansas and Nebraska about the improvidence of disgorgement, even for breach. And again, it goes to that's a breach of contract remedy if you prevail in your breach of contract claim, which was abandoned here. And so I think one of the challenging things in this case is the overlap between the breach and the injunction, but that's really easily resolved because the injunction did not relieve any contract performance. It didn't bless a breach. There's just no causal relationship here. The other cases I like that I do really want to mention quickly are Shadle and Barron's. Obviously, Shadle is discussed in our brief really heavily. If the injunction says pick a corn like X and you just stop picking it all, then you're not going to get to recover for the corn that you left rotting in the field. Barron's is also interesting. Barron's says, I'm going to foreclose on your property, so I got an injunction to keep you from taking any bricks off of your property. And the guy says, okay, I'm not going to touch the bricks, you got it. And then he watches rain wash all the bricks away. And then injunction was wrong, it should have been issued. He comes back and says, I want the value of those bricks. And the court says, no, that's not actually what the injunction said, that you have to continue performing your regular obligations and regular due diligence, and the only thing you were prohibited from doing was taking it and removing it, and that's not putting a tarp over it if it rains, right? And so the fact that your damages came from your own inaction, and I think the principle there is when your own restraint exceeds the restraint mandated by the injunction, you don't get to collect damages for that. And I think that's what we have here. Their own restraint by not going to the design professional, which they were not enjoined from doing before, and then when the injunction was lifted, they still didn't ripen their ability to arbitrate, and they never sued us for breach. And so when your own inaction here is the reason that you don't have contract remedies, not the fact of the injunction. And I'll save the rest. If there's any other questions, I'll save the rest for rebuttal. Thanks.
Good afternoon. Mark Weinhardt and Jeff Stone, both graduates of Cedar Rapids, Washington, home of the Warriors and proud alma mater of Hannah Stuelke, the starting center for the University of Iowa women's basketball team.
But know where you guys came from.
This is a case in which the state does not seriously contest, relative to the contract and property rights, the illegality of its early occupancy of the hospital, and does not at all contest the illegitimacy of the injunction that it obtained, does not contest that the early occupancy produced over $12 million in profit.
Is very different than the injunction. Yes or no?
The injunction, to use counsel's statement, the injunction green-lighted the breach, and I'll explain why. In order to look at that, first of all, the court needs to look at the governing law. This is a fact question of causation, and so juries in cases tried at law, which this was, almost never have the causation issue taken away from them. And substantively, when one looks at the law governing restitution, the standard for whether or not a loss as a result of an injunction is tied to the activity of the person who procured the injunction, that standard is directly or indirectly. Is it in consequence of the judicial act? That's the restatement third of unjust enrichment at section 18 and comment E. And overall, regarding the remedy, I would commend to this court, if this court looks at any set of authorities, it should look at sections 1, 3, and 18 of that restatement.
Let me ask you about section 18. That says a transfer or taking of property in compliance with or otherwise in consequence of a judgment that is subsequently reversed or avoided gives the disadvantaged party a claim in restitution. I mean, the university owns the land. It owns it's going to own the building that's being built. It never was the property. Modern Piping was just a contractor building something that was always to be owned by the university. So how does Restatement 18 apply here?
Absolutely was a property transfer and a property deprivation. First of all, under the construction contract, Modern Piping and the other contractors have a right to exclude the university from that space. That's what 9.7.1 exists to do, but also if you look at 14.2, which is the section that allows the university to terminate the contract from cause, or for cause, it talks about the university re-attaining a right of access to the space.
You said 9.71.1, right? Okay, that starts out, the owner may occupy or use any completed or partially completed portion at any stage when such portion is designated by separate agreement with the contractor. So it gave the university, they had the right to occupy as long as they got the agreement.
That's what the university did not do. They did not get that agreement. Instead, they enjoined enjoined Modern from being able to do anything about it. I do want to go back to the
To the $8 million that was the point of the injunction?
No, the entire purpose of obtaining this injunction was to prevent an arbitration in reaction to the university's desire to take over that space. And the internal communications by the university revealed at trial, including the gloating communications saying, don't let the design professional get anything because now we've got this injunction in place, revealed that it was absolutely the purpose and the plan of the university to use this injunction obtained figuratively in the dark of night in order to enable them to take over that space. And it's only after they obtain the injunction that they absolutely refuse, even though Modern is every week going them to try to obtain that contract, that partial use agreement. Every week the university is saying no and is refusing to.
Did Modern Piping seek to intervene or have the injunction lifted?
They were at least initially, ultimately they did. Initially,
Later was it?
7 months. But critically, the only relevance that that issue has to this litigation is whether or not Modern took actions to mitigate its damages. And mitigation of damages was out of this case because the state failed to plead it timely, and so they weren't allowed to make that argument to the jury, and that is not an issue that is appealed to this court.
I mean, you equate sort of property with these contract provisions that sort of that did create some right of exclusion. I mean, that strikes me as like if I hire somebody to come do work in my apartment and they say, we'd like you to, stay out for the day while we're doing the work. And I say, yes, sure, that's fine. It doesn't make it their property.
When you have a general contractor and a series of subs who are building a new building, and those are the facts in the Lundy versus Winnebago case, which is where the common law right to exclude comes from, then I do think that the contractor absolutely has the right to exclude the owner unless, under this contract, contractor and owner get together and reach an agreement about partial occupancy. And the university's express reason for getting this injunction was so that they wouldn't have to do that, so that they could march in to take this property over for free. And it might be that the injunction doesn't say you get to have partial use, but think about this. If you're the university and you know that the contract says that you can't get into this place, you don't have a right to it, and you want to get into it anyway fast, what would you do? You wouldn't go litigate your right, because that's a declaratory judgment action. It would take forever, and they'd lose on the terms of this contract. You would attack Modern's remedy. You would go in secret and get an ex parte injunction. You would name the AAA instead of Modern so that they're not right away involved in the case, and you would present them with a fait accompli, that before they can even lift a finger or do anything, they're already precluded from their only remedy, which is to arbitrate about this.
You couldn't have brought a breach of contract claim in district court for violating that provision?
Well, I think a serious risk for Modern would be if they go to court and try to undo this thing, and ultimately they did intervene. But
I thought the injunction didn't have anything to do with the occupancy. Could you have gone to court and filed a motion for breach of contract for the occupancy provision?
had they done that, there would have been a risk that they waive their arbitration right in that other case, which was a multi-million-dollar case, as counsel has indicated. But that sort of gets to their jurisdictional argument, and I'll stand on the briefing there unless the court has questions. The logical thing to do.
The consequence and what the risks would have been. I'm still struggling with why disgorgement is the appropriate remedy. So in the disgorgement cases that I've read, at least, it typically involves what Justice Mansfield indicated, which is someone obtaining a legal right to use other person's property and then capturing a profit that should have gone to the other party but for the injunction. And here, Modern Piping never had any entitlement to profits or revenue that the university made through the use of the hospital facility. So I don't know why disgorging it to Modern Piping is the appropriate remedy. Help me with that.
Because Modern Piping had a right for that 8-month period, they had a right to that property. And the university, by taking
profit from it. I mean, the cases that we're talking about in disgorgement is somebody is obtaining the right to make a profit off using other people's property, licensing their intellectual property, using their space, prohibiting them from using a space to compete. Your issue is just the breach. I mean, maybe there's contract damages, but I don't know why you get their profit.
Occupancy and profit to the university are the same thing. And all we have to establish under this law is that some right of Modern was transgressed. So this court...
Restitution, you have to establish, kind of like Justice McDonald said, that that it was property that your client would have owned and profited from. They weren't going to be running a hospital. That instead went to another party that they profited from.
With due respect, I disagree. The Unisys case, which Ms. Shelton and I know a little bit about, said that restitution measures the remedy by the gain obtained by the defendant and seeks disgorgement of that gain.
Still under 18 has to be property that was conveyed, you got the benefit of some property. It was never going to be Modern Piping's property. It was just something they were doing under a contract for the university to own.
Until the project is complete and Modern is off the job, it is Modern's property. They have a right to exclude.
What circumstances would Modern Piping have been entitled to profits from operating a hospital?
They would not have been entitled to operate a hospital because that's not their business.
With that building then?
Completed it without having to endure all of the safety problems and so forth that come with having interlopers in their space at the same time.
2.5 million
That is the 2.5. But as
Property issue. I mean, they don't have the right to sell it, right?
no, they don't have the right to sell it. Neither.
Business, they couldn't have said, hey, while under construction, we're going to take part of this and we're going to operate a showroom and do some sales for Modern Piping. So in what sense is it property if they can't use it for anything other than completing the university's hospital? They can't sell it. They can't sublease it. I mean, all they have is a contractual right to keep the university out of their way while they're building it.
Like a tenancy, it's like a lease. It is theirs until they turn it over. And there are reasons that the parties entered into a contract that gives them that exclusive right to the property unless they, A, negotiate an agreement that allows early occupancy, or B, Modern completes the job. And the university didn't want either one of those things. And so as a consequence, they got this illegal injunction instead.
If, the president of the University of Iowa had walked into the hospital and said, I'm just going to stay here, would your client have been able to get the police to kick him out for trespassing?
Yeah. On the basis that he is in a space that is Modern's exclusively until one of those two conditions that I mentioned is satisfied, and he's presenting a safety risk to a construction site. And so, yes, they could ask him to leave. Now, as a practical matter, would that happen? I think that's a somewhat unrealistic hypothetical. But
But I'm still trying to, as you could tell, the court is struggling, or some members of the court are struggling with this property concept, because it seems like the whole restitution has to hang on that.
First of all, I think that when one looks at the restatement sections that I've talked about in the Unisys case and so forth, the level of match between what the enjoined party lost and what the enjoining party gained does not have to be demonstrated at all. The first reporter's comment to Section 3 makes that abundantly clear, that those two things do not need to match, and that the thing that you look at is the gain rather than the loss. The other thing that I do want to point out is that both on this causation issue and on the question of what the right remedy is, there has been an abject failure of error preservation. As to the remedy question, it was not raised on directed verdict, not raised on judgment notwithstanding verdict. There is a remittitor motion that was made after trial, but not on this basis. It was made only on the basis of the jury was inflamed and its passions ran away with itself and so forth. And so that was never preserved. On the causation issue, the only argument that they made on directed verdict about causation is this mitigation of damages issue that Your Honor raised about, well, why didn't you sue, or why didn't you do something earlier than 7 months in order to try to do something about this, or why didn't you take the completely futile act of using the design professional, even though the design professional's decision couldn't go anywhere and couldn't be appealed through arbitration. And so the way that this case was tried below bears very scant relationship to the way that this appeal is being presented to the court now. And so the court has to get past that before the court can reach the merits. The bottom line of this case is that somebody is going to get a windfall. no matter what this court decides. The university has the windfall today. And the question is, should the university that concededly got a sanctionably bad injunction ex parte, should they be allowed to keep the windfall, or should Modern get the windfall? When all the litigation is done, somebody who, like the university, knowing full well what they did, gets a wrongful injunction in this way, should not be allowed to profit from that action. This court's decision is either going to create or erase a perverse incentive in injunction law in Iowa. It should erase it.
I have one more question. If we agree with the university that you're not entitled to the restitution, what's the proper resolution?
At least entitled to the $2.5 million in damages, and I think all of the injunction and restitution law would support that at minimum, and I don't think that the court needs to remand for a new trial to do that. There are cases where this court simply remands for a remittitor at a certain number, and that's what this court should do.
This started out as a motion for, we haven't talked about jurisdiction, which is fine, but it started out as a motion for fees and costs. That's really all you had at the very beginning. Does the $21,000 jury verdict that the university did not appeal, does that satisfy that?
That satisfies the motion for fees and costs, but for all the reasons we've stated in our briefing, that the district court did not abuse its discretion in allowing the additional counterclaim, and that's what we believe should be adjudicated now. Thank you.
Ms. Register.
I want to start with where they spent most of their time, which is the right to exclude. The Schmidt case disposes of this. It's not just that you had a technical right to do something, you have to show that you would have done it. In Schmidt, there was an injunction prohibiting someone from selling or transferring a mortgage note. She did not show that she would have sold or transferred that mortgage note. When the injunction was lifted, she sought damages for her restraint on her ability to sell and transfer that mortgage note. That was no dice. It's not just that you technically had a right that may have been affected by the injunction. The lesson of Schmidt is you actually had to have intended to do that right. And that's where this evidence completely falls apart. And so the way I understand it, their only theory to hang on to that restitution is their exclusion, which they never would have done. They have not shown they would have done that.
I mean, as you can see, some of us are interested in this argument that we would not equate sort of a property right with just the mere ability of a contractor to exclude people from the premises while they're working on the premises. I'm interested in your response on that, to Mr. Weinhardt's arguments about that this right to exclude, in effect, gave a property right to Modern Piping that the state and the university, by virtue of the injunction, took away. Let's assume we can get past the causation stuff, okay?
The question of restitution then is, we have their property, have we given it back? And the answer is yes. And so that would, to me, end the use of it. We had no benefit from it, right? Like, again, this caused delay. That delay has been paid for. Any property has been given back to the extent they lost a claim in arbitration, which they never had. That never happened here. That has been given back, and it was given back when the injunction was lifted, and they did nothing with it. And when the injunction was lifted, they didn't try to exclude us then either, and I think that matters.
Thanks. Air preservation, the argument that the directed verdict motion did not address causation as you're arguing on appeal.
The directed verdict vote in, which was substantially replicated in the JNOV, you'll hear a lot of what I'm saying today. It turned on the fact that you never sent this to the design professional, that you could have gone to another arbitrator, you never lost a forum. We made these, and the jury instruction was phrased of, was the benefit the university received done in compliance with the injunction? And so that's the language you see in the directed verdict and see it there. That's the same argument I'm making here, right? It wasn't compliance with the injunction that led to the breach, right? And it's the exact same argument. I invite you to read it, and I think you'll see that I'm right. A couple things, they mentioned that this is not de novo review. I do think it's de novo review because the essential remedy sought here is equitable. And I want to direct you to page 3, or day 3, page 32 of the trial. At that point, the parties are talking about whether the jury needs to be defined further what unjust enrichment is.
Feeling before I came to this case was a wrongful injunction is not tried to a jury. How did this end up being tried to a jury?
That's how. But we don't need to. But that still doesn't.
Well, it was tried to a jury with objections, and law action, all that. Isn't it a little late to argue it's de novo review?
I think our best case for that is Marksbury. A trial can have mixed elements of equity and law. And so when that happens, the inquiry you do is, okay, what was the essential nature of the relief sought? And this was a trial about unjust enrichment. And I do want to close the loop on the point I was making on page 32. And I'm going to explain why it's appropriate. And so, stay with me. We wanted, if the jury was going to hear this, right, that like, should we tell them what unjust enrichment means? And Counsel for Modern Piping says no, and he says, quote, we're in equity. And I think the equitable determination is really for the jury. And so what is being reviewed now is that equitable determination. I think when counsel tells the district court we're in equity right now, I think that goes up that way, and I don't think they should get to do an about face there. And I know it feels a little bit odd. I mean, Shadle is the best example of reviewing an injunction and what to do about it and how to set it right. This whole thing is
Iowa being reviewed de novo.
I would revert to Marksbury, which I think is the case. I think here it's mixed law and equity, and so then you ask what was this essentially really about? And I don't think the procedural aspects of a jury trial should trump the essential nature of the relief sought, which is equity here. They're asking you to do equity, and I don't think any version of these damages do equity.
I agree with you that the restitution doesn't match up. Your opposing counsel said that they're still entitled to the $2.5 million. Can you respond to that?
So if you think about there are three lanes that wrongful injunction claims can live. They can live in tort, they can live wrongful injunction, proximate damages. Usually those are against a bond. The third lane is this kind of exception to that, which is restitution. Their theory of restitution, that's where the 2.5 came from, right? That, well, at least we gave them a $2.5 million benefit. That was a theory of restitution. And so if there's no basis for restitution, I agree there's not, because again, nothing was done in compliance with the injunction. The breach was separate. And then I think that whole category is out. And so we're left with category 2, which is attorney's fees.
Was instructed to the jury that it was the benefit.
It was, what is the, like, was there a benefit conferred in compliance with the injunction? Was there a benefit, and is it inequitable?
Now I feel like I'm getting back into Game of Thrones jousting. I mean, looking at the case from, 30,000 feet, it does seem like the state, in retrospect, didn't pursue the world's greatest litigation strategy early on in this case.
Okay. Yeah.
Maybe something they would take back if they could do that again. And so, but now it sounds like, this 2.5 million, which, I mean, even your brief sort of implies they're entitled to that. You're now trying to say on a technicality they're not entitled to that?
If they're entitled to 2.5 from a breach, they should have sued us for breach of contract. The injunction.
No.
No, they've released all claims against University of Iowa for any breaches arising out of this contract.
I'm hearing that it didn't, I don't think, object to the jury instruction on restitution.
And as applied, objected to the instruction on restitution. That's instruction number 10. During trial, and I think it's page 26 of day 3, we made a categorical exception and said under Iowa law, there's no basis for restitution. And then you'll see through, before trial, we objected to restitution under these facts. We objected to restitution under these facts orally again at trial, and we did it again after trial. So we did.
Instructions were gone over?
26. And again, I think you heard, I'm way over. Can I briefly wrap up?
Way over. You go ahead and wrap up.
This is a wrongful injunction claim. I think the problem and the messiness we feel is because Modern Piping took a little bit of lane A, a little bit of lane B, and a little bit of lane C, and brought this amorphous thing. But the resolution here is straightforward. All of their damages stem from breach. The injunction did not bless a breach, not greenlight a breach, not sanction a breach. These are entirely different things. Any failure to get those damages came from Modern Piping's own inaction, not the injunction. And when that happens, they're not entitled to any category of restitution damages. And I ask that judgment be reversed. Thank you.
Et al. Versus Modern Piping is hereby submitted. Court is adjourned for today.